Hello everyone, today's topic is discharge of contracts. Discharge of a contract means the rights and obligations created by a contract come to an end. Parties are no more liable under the contract. It is the termination or cancellation of the contract. There are different modes of discharge of a contract. A contract may be discharged by agreement, by performance, by impossibility of performance, by operation of law, by lapse of time, and by breach. In today's video, I will discuss only one mode of discharge of a contract, that is, discharge by agreement. Let us discuss the point discharge of a contract by agreement. A contract may be discharged by mutual agreement of the concerned parties. When the parties enter into a fresh contract in place of original contract, the original contract is discharged. There are some important methods of discharging a contract by mutual agreement. They are as follows. Number 1, novation. Number 2, rescission. Number 3, alteration. Number 4, remission. Number 5, waiver. And number 6, acceptance of any other satisfaction. Let us discuss these points one by one. Novation. Novation means substitution of a new contract for the existing one. The old contract between the parties will be cancelled. In other words, we may say that the old contract is substituted by a new contract. Example: Raja owed rupees 70,000 to Pritham under a contract. Afterwards, Raja, Pritham and Rahul entered into a new contract, whereby Pritham would accept Rahul as his debtor instead of Raja. In this case, the original contract between Raja and Pritham is discharged. Next point, rescission. The term rescission means cancellation of the contract. When two parties enter into a contract, some legal rights and legal obligations are created. When a party fails to perform his obligations, the other party may rescind or cancel the contract. Thus, the contract is discharged. Example: Suraj agreed to sell his car to Manoj for rupees 2 lakhs. And Manoj agreed to pay the price after the delivery of the car. Afterwards, Suraj refused to deliver the car to Manoj. In this case, Manoj becomes entitled to cancel the contract. The main difference between novation and rescission is that in novation, the old contract is discharged and a new contract comes into existence. But in case of rescission, the old contract is discharged and no new contract comes into existence. Next point, alteration. Next point, alteration. The term alteration means change in one or more of the terms of the contract. The alteration is valid if it is made with the consent of all the parties. The old contract is discharged and the parties are bound by the new contract. Example: Karan agreed to supply to Arjun 100 bags of cement at the rate of rupees 400 per bag. It was agreed between them that the delivery was to be made in 5 equal installments. The first supply was to commence from 1st December 2022. Afterwards, Karan and Arjun changed the terms of the contract that the delivery would be made in 2 equal installments and the price would be rupees 420 per bag. So in this case, the old contract is discharged and the parties are bound by the new contract. Next point, remission. The term remission means the acceptance of lesser fulfillment of the promise made by the other party. Example, Babu borrowed rupees 80,000 from Raju and promised to pay the due amount on 28th October 2022. On the due date, Babu paid rupees 60,000 only to Raju and Raju accepted it in full satisfaction. In this case, Babu is discharged from his liability of rupees 20,000. Next point, waiver. The term waiver means abandoning, that is, giving up the rights. The party who is entitled to claim performance of the contract may give up his right. On waiver, the other party to the contract is discharged from his obligations under the contract. Example, Kajol promised to paint a picture for Madhu. Afterwards, Madhu forbade her to paint the picture. In this case, Madhu has waived her right to claim the performance. Therefore, Kajol is no longer liable to perform the promise. Next point, acceptance of any other satisfaction. Sometimes the party who has the right to demand the performance of the contract may accept any other satisfaction instead of the performance of the promise made by the other party. When he accepts the other satisfaction, his acceptance discharges the liability of the other party. These are the points of discharge of a contract by agreement. That's all for today. Thank you very much for watching and listening.